Welcome back to this week's episode of Tort Talks. Thank you. We have John and Joe with me today. I am back from vacation. We have an action-packed week, gentlemen. Let's get into it. So, social media addiction. Last week, you all discussed the first upcoming trial in November in Los Angeles County Superior Court. An important decision came about admissibility of plaintiffs' experts. What can you tell us about this ruling?
Yeah, Mark, like you mentioned, we have a lot of momentum going in these social media addiction cases. We got the good news that the first bellwether case is going to move forward in November. We got some really good news, like you just mentioned, regarding the admissibility of plaintiffs' experts. So in this case, the judge evaluated all of our experts. The defendants challenged every single one. And the issue before the court was whether or not the experts rely upon reliable methodology when reaching their opinion. So as we see in each case, the defendants attacked each one of our experts. The judge ultimately ruled in our favor and only excluded one of our experts, but all of the others got in. So what this means is when we get to trial, we're going to be able to present the fact evidence, but also have the expert testimony come in behind it to help explain to the jury about the techniques and the things that the defendants did, these big tech companies did, that led to the addiction of our clients. So a huge ruling. If we had lost this ruling, it potentially could have set back the entire litigation and we would have been back at square one. So we're all really excited about this development.
That's excellent news.
Yeah, very similar to social media. Roblox, it's sort of social media platform for kids. There's an MDL being sought there, and we're hearing real horror stories about kids using Roblox and various issues that they're having throughout the country. A petition seeking consolidation was filed with the JPML seeking to form an MDL. What should we expect next related to this motion as it heats up?
Yeah, like you said, John, this is a similar case to what we're seeing in the social media addiction, the video game addiction cases. Roblox is an online gaming platform. And what we just saw was in September, a couple firms filed a petition for consolidation in front of the Judicial Panel Multi-District Litigation. So for those who might not be as experienced as you with mass torts, in order for an MDL to be formed, usually the plaintiffs file this petition saying that there's a large number of cases, usually above 25 cases, that involve similar defendants, similar facts, and similar injuries. And for the sake of judicial economy, the cases should be in front of one judge who's going to give us consistent rulings. So we just saw that motion filed. What happened is there's over 30 cases that are pending throughout the country. About half of the cases right now are pending in the Northern District of California. So the petition sought consolidation in front of a judge in the Northern District of California. What we're going to see next is the defendant's response. I anticipate they're going to say that there shouldn't be an MDL formed because it involves different facts, mainly the length of time that the users were using the platform and the injuries they suffered. And then in addition to that, the defendants hate being in the Northern District of California, so they'll probably propose another jurisdiction. I'd expect it to be somewhere in New York. Ultimately, we'll end up having a hearing at the last JPML hearing in December. I expect there to be an MDL formed before the end of 25. This is a really important case with really important issues, so we'll stay on top of it here over the next couple months.
Yeah, this is an exciting one to watch, see from the beginning. This is also another one that affects children, so very interested to see how this unfolds.
Is this Roblox from a video game addiction standpoint, or is this Roblox from like the sexual assault of minors standpoint?
Yeah, the latter one there, John.
The video game addiction continues to proceed down its own path, and then this Roblox minor sexual assault cases are seeking consolidation. Got it. Thank you.
NEC. Last time we talked about this lawsuit, we were discussing the summary judgment win for defendants in the MDL. What is happening now with the census order entered by the MDL judge?
Like you said, we had a setback this summer where the judge granted summary judgment on defendant's motion, knocking out the next bellwether case. We have a similar argument coming up in October. I believe it's October 14th, where summary judgment motion's being argued in another bellwether case. Meanwhile, while that's all going on, a positive development, I'll say, is that the judge ordered a census. So basically, this is a questionnaire that needs to be completed. Usually, once the litigation is ongoing, we refer to this form as a plaintiff profile form. The judge in this litigation is requiring that the census form be completed for all filed and unfiled cases, basically giving the parties 90 days to get this completed. It seems like the judge is trying to get their arms around the total inventory so there's not that shock like we saw in AFFF, where tens of thousands of cases ended up being filed. For me, this points to the judge wanting to have a clear indication of the total number of cases to help streamline and really allow the parties to move forward with settlement discussions. Without this information, it's really impossible for the parties to have substantive discussions. So I think this is a positive development. Usually when there's some sort of census or requirement from the court to get information, they really have an eye on settlement, even though I think that's down the line in these cases, because like I said, the defendants definitely have some momentum on their side with the summary judgment wins.
It's good. It's great to see that another case, this time NEC, just making progress after being stalled for a little while. Moving on to our next case type, we're going to talk about Roundup. We're still waiting on the Solicitor General to provide a response on whether the Supreme Court should consider Bayer's preemption argument. What is happening with this litigation?
Right, John. We're waiting for the Solicitor General to come in. As you remember before, under the Biden administration, the Solicitor General said that they didn't believe that the case should be taken up to the Supreme Court, and ultimately the Supreme Court declined to hear it. We're waiting to see if the Solicitor General under the current administration changes their recommendation. But while that's going on, we still have tens of thousands of cases pending throughout the country, mainly focused in Missouri State Court. What we're seeing there is that it appears cases are being settled one by one. So cases comes up for a trial. Instead of moving forward with the trial, the case disappears off of the docket. It appears that their individual case settlements ongoing, which is Bayer's strategy now to allow for the Supreme Court petition to pay out. While that's all ongoing, we recently saw, unrelated to the personal injury cases, a class action settlement involving investors in Bayer. They, in essence, claimed that they didn't reveal initially the true potential liabilities that Monsanto or Bayer faced when Bayer purchased the company. The settlement was for about $38 million. I think it's significant here because it just shows another avenue that Bayer's trying to clear its books, get past this Roundup litigation.
Wow, that is some interesting intel.
I did not know that one.
Yeah, did not hear about that one.
That's why you guys have me here.
So, Tylenol mass tort. So the oral argument was postponed. What's going on there? I know there's been a ton of news about Tylenol coming down from the FDA and the president. What's new here?
Yeah, like we talked about last week, John, Tylenol is in the news everywhere, even outside mass torts. We were waiting for a long time to have the oral argument before the Second Circuit about whether or not the judge in the federal court case in our MDL overstepped the boundaries in excluding plaintiffs' experts. There was a lot of momentum building toward that argument, which was going to be the first week in October. Ultimately, because of these recent developments and like you mentioned, Mark, the FDA coming out, the judge in the Second Circuit decided to postpone the arguments to the middle of November to kind of let the dust settle a little bit and each party provide information on how this decision and the FDA's input, if it impacts it at all. To me, this signals that it's a good sign for plaintiffs. Delaying this a little bit further, I think, makes sense for both parties, but I think it ultimately is going to end up on our side being a win, and I'm really hoping we can get that decision overturned and these cases back in the beginning of 26.
So yeah, another exciting week in mass torts on Tort Talks. Once again, the most valuable 10 minutes in mass tort you can have every week. Joe, thank you for being here. Next week, I think we're going to start doing our new series and we're going to start doing some power rankings.
Yeah, thanks for having me, guys. Looking forward to the power rankings coming out next month.